From the KPFK studios in Southern California,
it's the Ralph Nader Radio Hour.
Stand up, you've been sitting way too long.
Welcome to the Ralph Nader Radio Hour. My name is Steve Scrovan, along with my co-host David Feldman, who I have to say my working relationship with David is very good. It's as functional as the working relationship between Donald Trump and Mitch McConnell, I'd say. Would you say that, David?
Yes, and you've never called me a moron.
Well, not out loud. And we also have the man of the hour, Ralph Nader. Hello, Ralph.
Hello. Today we have two topics that affect every listener and every person in this country. It deals with slipping and falling, and it deals with the fine print contracts.
You are correct, sir. On the show today, we're going to be talking about the two F's, floors and fine print. And when I say fine print, I'm not talking about like excellent calligraphy or anything like that. I'm talking about the fine print contained in all of those contracts you and I sign when we buy something or pay for a service, especially online when we click I agree. We're going to explore exactly what we are agreeing to and why it may not be good for us with law professor Margaret Jane Radin, author of Boilerplate, The Fine Print, Vanishing Rights, and the Rule of Law. Then we're going to welcome back Russell Kendzior. Mr. Kendzior is an expert on slip and fall accident prevention, so he's going to tell us how we can better stand on our own 2 feet. His book is Floored, Real-Life Stories from a Slip and Fall Expert Witness. We will, as always, hear about the latest misconduct being perpetrated in the executive suites of America with corporate crime reporter Russell Mokhiber. And if we have time, we'll dive into more listener questions. But first, let's get to the fine print. David?
Margaret Jane Radin is the University of Michigan Henry King Ransom Professor of Law Emerita. She taught courses about contracts and patents and international intellectual property. Her award-winning book, Boilerplate, The Fine Print, Vanishing Rights, and the Rule of Law, explores the problems posed for the legal system and consumers by fine print contracts. Welcome to the Ralph Nader Radio Hour, Professor Margaret Jane Radin.
Thank you very much for inviting me. Glad to be here.
Welcome indeed. Let's start with a little story about the child of your niece when she was 3 years old, and she attended a birthday party at a gymnastic facility for young children, and she had to sign a form. And I'll quote the core of the contract that she had to sign. Quote, "The undersigned agrees to defend, indemnify, and hold harmless this facility, its officers, managers, members, employees, servants, agents, and coaches, instructors, and their successors, and assigns from and against all legal liability, claims, suits, damages, losses, and expenses, including attorney fees, threatened or incurred and arising from the child's participation or from any cause whatsoever." End quote. That, listeners, is just part of the indentured servitude, what I call contract peonage, that we all are confronted with because companies don't compete over who has the least exclusive and damaging fine print contract. Ford Motor Company and GM and Metropolitan Life and Prudential and Visa and MasterCard, they all have pretty much the same fine print, and a lot of them exclude your right to go to court with your grievance, something no government can do constitutionally to you. And they also have clauses that say they can change the contract, increase your frequent flyer mileage unilaterally because somewhere in this fine print on page 20, you agreed to it. So let's ask arguably the world's expert on these fine print contracts that we sign on a dotted line or click on, a question about the enormous damage this does to us as a democratic society.
There's no question that they're enormously damaging and getting worse and worse. It started with insurance contracts a long time ago when things were still typed out or at least printed out, and now we have information society and these things are everywhere. And if I tried to read every one of them, even though I know what they mean, I wouldn't have a life. So you are right, we're back to indentured servant status pretty much. The fine print is stripping consumers and employees of core legal rights, especially, as you say, the right to the day in court, which the Constitution says we have. Now this seems like an empty promise a lot of the time. I can be a little more specific here if I'm not like a professor running on too much.
By all means.
The clause that you read that happened to the parent of my niece who had to decide to keep her child home from a party or sign this thing is called an exculpatory clause. It says you can't sue us no matter what we do to you. And courts allow firms to do this for services, not sale of goods. That's a legal nicety. But basically, this exculpatory clause thing is a trick used by insurance companies. When they insure a small business like this gym or a daycare center or something, they insure that business against hurting a consumer, but then they try to make the consumer take the hit instead. It really should be illegal. I don't know why it's not.
Why don't the judges just throw it out? There's a unconscionable doctrine in contract law, as you know very well, where some provisions in these fine print contracts are so unconscionable that the courts have from time to time thrown them out. But that's difficult.
Occasionally they do throw them out. At least it happens, even though the clause that you read said you can't sue us no matter what we do to you, basically. But technically speaking, the courts would at least stop at negligence. You can't sue us for our own negligence. They'll always throw out something where it says we hurt you on purpose or we did something else to you, gross negligence. The problem is then the consumer won't know that, and the consumer would have to argue about it instead of saying this is unconscionable. I should say occasionally they may be held unconscionable somewhere, but unconscionability is a one-time argument to one court, and they can just use the same clause in other states and other courts. So it's not a very good, trying to litigate about them one by one is not a very good remedy. They should be made illegal, and there are ideas about how to do that, but I'm not sure it's going to be up to the courts, really.
Well, we have a precedent here. The Affordable Care Act, for example, made illegal fine print and health insurance contracts that said that you can't have your adult child be under your coverage. And what the Affordable Care Act said was, we're going to rule that the adult child can have coverage under the family policy up to the age of 26. Federal Trade Commission has rules like against the funeral industry for unconscionable provisions. What do you think the potential of expanding that is?
That's a very interesting question. The Federal Trade Commission can ban or remedy unfair or deceptive methods of doing business. Right now, they're going after phony student loan relief scams, which I'm seeing on television all over the place, and I have to say that's good. They could, as far as I know, legally, they could go after these arbitration and exculpatory clauses and choice of forum clauses and the other things you mentioned. They could go after those against consumers that effectively deny them their relief. They could go after outrageous clauses. They don't. I'm not sure why they don't, because I'm not up on the politics of who gets appointed to the Federal Trade Commission, and Ralph, I bet you are.
Well, the problem is so massive, no matter what progress there is here and there, a court decision or what have you, 99% of the contracts we'll ever sign in our lives are these fine print contracts, these click-on contracts, and they're getting more one-sided, more brutal, more cruel, and it's a shame on our profession that these corporate lawyers are working overtime to think more and more ways, in effect, to say to tens of millions of consumers, conservative, liberal, you name it, that you are not protected by our system of law and by our Constitution. I just looked at the Airbnb contract with homeowners. It's like dozens of pages, escaping responsibility and putting it on the homeowner. So
we should talk a little bit about the arbitration clause, because that's a thing which is now being okay. It basically cuts out class actions and cuts out relief for many small transactions, and you have to go to an arbitrator individually, which is private, and there's no record, so it cuts out the common law. And the Supreme Court, when Scalia was alive and heading this, ruled over and over again that state law is not allowed to fix this. So arbitration clauses, we have to get Congress to fix it, and the arbitration fairness clause is entered every year and never makes it out of committee. And these clauses are especially awful for employees because you can't bring a discrimination suit if there's no class action, and you can't bring class action if you're limited to arbitration.
Explain class action. Explain class action.
As you know, and a rule against using arbitration against consumers and employees in financial transactions, and right now the administration is fighting it tooth and nail. And the same thing happened with arbitration clauses in nursing homes, where you'd have to arbitrate while they're killing your father, who has to live there for the rest of his uncomfortable life, and they don't tend him, and he gets a bed sore which kills him or something. It's just awful. But the people in control of how Medicare works now are against this. So there's an uphill battle. I should say that, Ralph, that some of your consumer network and some other people are battling this with great energy, and that's a good thing to do. But right now, arbitration, which is in play, but it looks like we're not going to be able to get rid of it as used against people who therefore never have a right to a day in court. And that is an empty promise now if we allow this to continue. As you can see, I'm very upset about this.
Well, we've been talking with Professor Margaret Jane Radin, who's written this classic book, Boilerplate, on the fine print contracts that rule our lives in the marketplace. And when I was in law school, these fine print contracts were far less onerous than they are now. These corporate lawyers have been working overtime to make sure that their corporate clients escape the rule of law. Sometimes I think that's what is the most that they do every day, is to get their corporations to escape the rule of law that is supposed to cover everybody. Let's talk about fighting back here. Let's say the following. In a book we did about over 40 years ago on lemon cars, defective cars, we drafted a consumer purchase contract and asked our readers, if they go buy a car at a dealership, to put the contract on the table in front of the salesman and say, please, I'm going to buy this Pontiac or this Chevrolet or this Ford. Here's my contract. Please sign on the dotted line. And the first person who did that, who wrote us, said that the dealer called the police. I mean, that's how totally off the wall they are, that if they see a consumer contract, the second person, the salesman shouted, "You dirty communists, get out of here." So we're talking about the great destruction of freedom of contract in our history. It's one of the great pillars of our freedom. Conservatives recognize that. But the conservative lobbies in this country, I'm not talking about the corporate lobbies, they are not rising to the occasion with progressive consumer groups to try to do something about this. So lesson number one, what would you advise consumers to do on a one-on-one basis if they can do anything?
Yeah. Okay, I want to advise what consumers might do, and I also want to say that we also, law professors, have a responsibility too, not just attorneys who swear to uphold the law. We need to teach contract much better in the elite law schools. I've been teaching contract in law schools for a long time, and I'm sure that we haven't prepared people for what's out there. And law students come in fairly idealistic, and they leave thinking I might as well join the corporate bunch and make money. I mean, this is not true of everyone, of course, but it's
well, since you raise this, I've often asked, if I can interrupt you, you have all these contract professors. They know all about these fine print contracts.
Yeah, we do.
They have students sitting in their classroom who are already burdened by Sallie Mae student loans and other rapacious fine print contracts. Why, over the years, why didn't they try to defend their own students and raise a ruckus?
You know, you've asked me that question before, and I don't know. I would think that some of the law professors are busy trying to get tenure, and some of the people teaching are adjuncts or, have to go from school to school. And so it really devolves on senior law professors. And I think even though, conservative people think that law schools are too, what shall I say, left wing, really they're very conservative in my view, and they don't think about this. So the way I've never met a law professor that told me how worried he or she is about the student loan things, even though they have children who probably have to borrow, but maybe I don't know. I really can't answer that question. I can tell you that the way contracts is taught at the elite law schools is not helping. Because there are case books which have appellate cases from the past where you're supposed to show what the arcane arguments are about the parallel evidence rule or what courts would think of as consideration that would engender a contract. And if boilerplate gets taught, I've been asked to give a guest lecture a few times, boilerplate gets one lecture, if that. And these contract books that are used to teach contract to first-year law students, there's nothing on statutory law. There's nothing that tells students what the Federal Trade Commission can or can't do either. So there's nothing on administrative law. There's nothing on consumer law. So law students are not getting a good picture of contracts. And then when they go into practice, they'll be told what their client needs. And, members of the bar have an obligation to society as a whole, too, to uphold the law, but they won't know how to do that.
That is a serious problem which our profession's got to address. And we also have to go after some of these corporate attorneys who are the brain trusts. There's one in Philadelphia who's very proud of how many of his clients can get away from having any responsibility in the contracts for their goods and services. But you, in an article you wrote for the Los Angeles Times in 2013, you asked the question, what is to be done? And you talk about legislative action, for example, and what the courts should do. But then you say, quote, meanwhile, the next time you're confronted with, quote, terms and conditions, unquote, like with Facebook or Airbnb or Amazon, that those are my words, that back to your words, that seek to take away your right to redress, just delete and initial the clause before you sign the form. If the business continues to serve you, a court might consider that it accepted your amendment. Besides, you will at least have lodged a protest. If enough of us do it, firms that want our patronage may change their forms, or their competitors may. Can you elaborate that? Exactly what do you advise a consumer to do when they're signing a mortgage document or a credit card agreement?
This is a question that I can't do very well on. I think individuals should push back when they can, and I think it's easier to do with the contracts that you meet at the gym or at someplace else, but very hard to do with a mortgage because they're just going to kick you out. The last time I refinanced a mortgage, I got a terrible clause about even if we lose your documents, we still have to make you pay, and I signed it because I had no choice. So I think there is no choice. I think the way to push back has got to be more organizing state attorney general if we can, do what you can at the state level. I think we can organize online. Lately I thought if I had an arbitration clause blocker, I would use it. I wouldn't use firms that used arbitration clauses. And if we had enough people that did that, even a small percentage, not everybody would have to do it. If we lowered their sales and profits just a bit, maybe they would think twice. There are evidence of pushback working. So the most recent one is the Equifax arbitration clause, because as you know, as early in September, the Equifax had to reveal this massive data breach, and then they said if you can apply to us and we can help protect you. But it turned out there was an arbitration clause in there. So there was massive pushback against that, and they withdrew it within less than a week. So I think it's up to us to educate people to push back however they can.
You know what I do when I sign these contracts?
I don't know what you do. What do you do, really?
I put a little at the end, UD, which means under duress. So that if it ever comes to a public decision, I can say, look, I put UD. And by the way, these companies do not compete. So you can't say, well, I don't like Ford Motor Company's installment loan contract. I'm going to go to GM. So it could be an antitrust issue. And you have described these contracts as so damaging for wrongfully injured people that keeps these people from using our courts and trial by jury under the Seventh Amendment for a redress, that you've called these contracts themselves a tort. In other words, a wrongful injury.
Yeah,
Can you explain that?
I now think I'm trying to go at this in different ways. Every time I publish something, I try to find a different way to do this. So right now, I think that we should stop calling them contracts. I think there's no agreement. I think people are losing. It's not both sides are gaining. It's only one-sided. I think we should. That's why I wanted to call it a tort. It's against somebody, and it's not a contract. And I think
there's no. You mean there's no real consent?
They're bad contracts
when you say,
rather than saying they're not contracts.
When you say it's not a contract, what you're really saying is pages and pages of gobbledygook and legal jargon.
Yeah.
There's really no consent by the consumer.
That's right. That's what I'm saying. There's no consent. Consent is fictitious, and everybody knows that. And I think if companies know they're doing a fictitious thing, they shouldn't be allowed to do it. An analogy is false advertising. Especially if they know it, and even if they don't know it, companies are not allowed to advertise falsely to the public. They will be punished. So I think, especially since everybody knows, and certainly including the companies that deploy this stuff, everybody knows that it's fictitious. I think they should be punished, just like deceptive advertising. But I'm unclear who's going to do that, because I'm afraid the Federal Trade Commission isn't going to get there.
We got to make it a public issue, and I think, in the old days when they burned their draft cards in protest against the Vietnam War, maybe people should have a safe burnout of their credit cards and debit cards.
That's a good idea, and I think some of that was tried in Washington, if I'm not wrong, and probably people that were associated with you, I think. And we should do whatever we can to make sure that people know that we don't like it, and we're not going to support their products. And I also think, just going back to law school, I think we should make ourselves that are involved in teaching law students responsible for teaching them that to be a lawyer means you have an obligation, and the obligation is not merely to take away people's rights and make corporate clients not have to spend money when they do things which hurt people. So I'm hoping for a whole way to approach this, but
we have a website. We had a project on this. It's suspended for the time, but the website's still very useful, faircontracts.org. You'll get a good education. You'll get a good education and some recommendations of what you can do. Let's get a question from either Steve or David. I'm sure they have a number of them listening to our discussion.
Yes, to me it sounds like there's really, if I'm not hearing that correctly, there's really nothing we can do as an individual. When I'm going to the doctor, I need to see the doctor, and I have to sign something that says I won't sue, I'll submit to arbitration if anything happens, but I need to see this doctor. So as individuals, we can't do anything, we're saying.
Well, yes, I think individuals need to be absolutely multiplied. So I think the more publicity we can give this, the more that we can help individuals do what's needed, and that's where a site like faircontracts.org is very useful. And I can say again, Equifax had the arbitration clause. So many people said we can't stand this that they pushed. So many people pushed back that they relinquished it, as far as I understand. And I think that's better to try to punish corporations that do this by not using their services if we can help it, rather than trying to get Congress to pass something, which has seemed to be very difficult. As far as things that are necessary, like daycare centers or going to the doctor, it's much harder because if you have to sign something going to a doctor, you can't say, I won't let you treat me unless you don't do this. There probably are doctors that don't do that. Some doctors are ethical. I don't know how you find one, and I think that, the terrible health insurance system that the U.S. has is not the subject of this particular discussion. It makes it harder to find somebody else, though, for sure.
It's encouraging that there are some companies now saying that they don't use arbitration clauses.
Yeah, there
and
are.
Telecommunication, there's a bank here and there. And when that happens, people ought to say, that's good,
Right.
and start distinguishing between severities of contract servitude or peonage. You're living in Toronto now, and you teach part-time at the University of Toronto Law School. Has Canada done anything different on this, or any other Western country or any country? Do they do a better job?
Yes, all Western countries do a better job, even Canada. The provinces have control over arbitration clauses, and several of them have disallowed arbitration clauses against consumers. Just don't use them. And I don't think that even Canada is a common law country. I don't think they would allow the exculpatory clauses that are allowed in the U.S., like the one you read about my niece and the birthday party. And I'm pretty sure that Canada won't allow these forum choice clauses, which send you to some place really far away to engage in suing a company, meaning you can't afford to do it. So, and I think that Quebec and all the civil law countries, such as in the European Union, I'm not counting UK, I don't even know whether they're in, but all of those countries don't allow these things that cut out remedies and don't allow the supposed individual right to contract, which does away actually with the right to really contract and the right to really bring actions in court. So I think every Western country is better than the U.S., and the U.S. is an outlier. I am not an expert on these other countries because when I was taught law, it was strictly U.S.-centric, but having heard something of contract theory on the continent and in Canada, I would say everyone is trying harder to fit with the rule of law than the U.S. is right now.
Well, we need to have the awareness. People have to speak up. Even if they're trapped, they can make their protests known. They can pressure their legislatures, their state attorney generals, the Federal Trade Commission, until we get enough wiggle room to turn this into a major movement. We've been talking with Professor Margaret Jane Radin, who taught at University of California, Berkeley Law School, Bolt Hall. She taught at the University of Michigan Law School. She's the author of the classic book, Boilerplate, The Fine Print, Vanishing Rights, and the Rule of Law. This is not a small item. It's one of the great pillars of our freedom as a society. It's been destroyed, and we've got to get it back. Thank you very much, Professor Radin.
Thank you so much for inviting me, Ralph, and thank you to the moderators, too. Much appreciated.
You're welcome.
Thank you, Professor.
Bye for now.
Now let's take a minute to link up with our corporate crime reporter, Russell Mokhiber.
From the National Press Building in Washington, D.C., this is your Corporate Crime Reporter Morning Minute for Friday, October 20, 2017. I'm Russell Mokhiber. Last month, Allergan transferred the patents for its dry eye medicine, Restasis, to New York State's St. Regis Mohawk tribe, claiming the group's status as a sovereign nation meant the patents could not be reviewed by the U.S. Patent Office. That's according to a report from Reuters. A federal judge, William Bryson, this week expressed concerns about the legitimacy of the tribal transfer, calling it a ploy by Allergan to rent the tribe's sovereign immunity. He did not rule directly on whether the transfer was legal, however, because that question was not squarely before him. But his decision rendered Allergan's move largely meaningless since he invalidated the Restasis patents himself instead of waiting for the Patent Office to rule. For the Corporate Crime Reporter, I'm Russell Mokhiber.
Thank you, Russell. Russell Kenzier is the president of Traction Experts Incorporated and founder of the National Floor Safety Institute. Mr. Kenzier is internationally recognized as the leading expert on slip and fall accident prevention and has been retained in over 400 such lawsuits. He has a new book out chronicling that testimony. entitled Floored, Real Life Stories from a Slip and Fall Expert Witness. We had you on the show about a year ago, and I mean this, you changed the way I walk. I pay attention now to the floor. Welcome back to the Ralph Nader Radio Hour, Russell Kenzier.
Great, thank you. Good to be back. And since we last spoke, my number of retentions has gone from 400 to almost 800.
Well, Russell, your new book is called Floored, Real Life Stories from a Slip and Fall Expert Witness. And I want to set the stage for this because there isn't anybody listening to this program who hasn't fallen or slipped sometime in their life, once or more. So it affects everybody. But I want to set the stage of how you go right straight to the skepticism that you have to deal with. And it's the first paragraph of your book, which I'll quote. It's pretty short. Quote, "Every time I'm asked, so what do you do? I reply, I'm a safety expert and expert witness in cases involving a slip, trip, and fall. To which they usually reply, really? Slips and falls? Aren't those just scams staged by con artists? Welcome to my world, you say, a world of misunderstanding and mischaracterization of slip, trip, and fall victims. I don't think there's any category of safety whose victims are demonized more from that of slips, trips, and falls." End quote. From your book, just out, Floored, Real Life Stories from a Slip and Fall Expert Witness. So let's get down to the actual range of devastating injuries and deaths that come from these slip, trip, and fall victims before we start getting into your expertise about how to minimize, mitigate, and prevent such slip, trip, and falls. Give us some statistics, Russell Kenzier, about what happens in a given year to the American people who slip, trip, and fall.
As you know, Ralph, injury data is always reviewed in past terms, past tense. The most current data is reflecting from 2015, which states that the lifetime odds of a person dying as a result in an accidental fall are about 1 out of 127. That's right behind motor vehicle incidents, which is 1 out of 114. So there's almost the same number of people dying as a result of a fall as there are a number of people dying as a result of an automobile injury or crash. Falls in its totality represents about 9 million injuries each year, of which about 2.5 million, almost 3 million, are disproportionately affecting the elderly, people over the age of 65.
And Russell, let me interrupt. These are falls that can be in your homes, they can be on the street, they can be in stores, in shopping malls, they could be in a variety of buildings, office buildings. They can be anywhere. That's what you're talking about, right?
Yeah, absolutely. Accidental falls take place pretty much everywhere. Most occur in the home, but as the baby boomer generation ages, and again, that's the age group that's most likely affected both by injuries and fatalities, but as the baby boomer generation ages, which, as we know, are retiring to the tune of 10,000 a day, they're more active than their parents' generation. They're shopping, they're out and about, they're working longer. In fact, it's not uncommon to find people working well into their 70s today. And so, yeah, accidental falls, injuries, and fatalities really can happen everywhere, and they do. As you saw in my book, Ralph, I've got cases. I had a case where a lady slipped and fell going to her husband's funeral right there in the cemetery. They happen everywhere.
Let's now examine the reasons for these falls. I mean, most people think it's the person's fault. They were careless, they didn't look, they lunged, they were distracted, whatever. It's the person's fault. But you've made a career out of a much more careful analysis of the conditions that lead to these falls, human and intangible conditions about the situation on floors and pavements, etc. Why don't you inform us about that?
Since 1997, the National Floor Safety Institute, or NFSI, which I founded along with 9 other companies back in 1997, has been collecting data. What we've found is that about 55% of all slips, trips, and falls take place due to a hazardous walkway, meaning the floor itself has some inherent danger, hazardous condition Approximately 24% of all slips, trips, and falls take place due to improper footwear. Most of the time, that's work-related footwear, people slipping and falling in their job. But we also see a relationship between shoes like flip-flops that are connected to a lot of slip and fall injuries. The remaining three components, or roughly 25% of the remaining causes, it deals with such factors as training, posting of wet floor signs, and believe it or not, Ralph, the smallest portion, the smallest piece of the slip, trip, and fall pie is fraud. Fraud represents only 3 to 5% of slip,
Where you mean
trip, and
they
fall.
fake it? You mean they fake it in order to pursue some claim?
Yeah, faking it is actually very, very rare. It doesn't happen often, and those people who do fake a claim are a very small number of people, but they're very active. But they get disproportionately represented in the media. In fact, the media will oftentimes portray all victims of falls as being fraudsters and really plays down the legitimacy of what really is the nation's leading health and safety problem.
Let me interject another factor. Dr. Sidney Wolfe, in his legendary book, Worst Pills, Best Pills, talks about medicines that people take. Sometimes they take them in combination with one another, and they don't know what the impact is on their body. But he pointed out that a great many falls come from people who are on prescription drugs or other kinds of drugs, and they get dizzy, nauseous, and they fall and they break a hip or a knee. What's your research about that?
Well, that's absolutely correct. The three, what we call contributing factors, deal with environmental factors like the floors and shoes, things I just mentioned. There's also physiological factors like you've described, medication, perception, vision, hearing, which is, of course, related to balance. And again, as we age, those factors become more and more important. It's not uncommon for many seniors to be on multiple forms of medications, and as they are ingesting these compounds, it does affect their perception. And so, although that's not a direct cause of a fall, those types of conditions certainly do contribute to the number of falls. But again, Ralph, we're looking across the entire spectrum of age. Even young children who are not on medication, we're seeing single, sometimes double-digit increases over multiple years of injuries as a result of a fall. Well,
children are more medicated now than ever before, so that must be also a factor. Let's go to what I find most fascinating about your work, Russell Kinzer, who's just come out with a book called Floored, Real-Life Stories from a Slip and Fall Expert Witness. But you've been concerned about the flooring industry, which is a lobby that doesn't like to be told how to use materials that will increase traction and reduce slipping and falling and being seriously or modestly harmed.
Well, that's correct, Ralph. Sadly, most manufacturers of floor coverings do not test their products' slip resistance, nor do they provide any form of labeling to the consumer as to how safe or slippery their products are. So at the end of the day, the consumer is left on their own to make a decision, oftentimes a flawed decision, as to what type of flooring material to put in their house, only to result in a serious injury. And again,
what are the categories of flooring material? You're talking about carpets, linoleum. Go ahead. Go through the categories.
Yeah, the primary categories are carpeting. In fact, most floor coverings that are sold in the United States are carpet flooring materials, which tend to present a high level of slip resistance. But what's called hard surface floors, like ceramic tile, marble, any type of stone, vinyl floors, laminate floors, wood floors, anything that's a solid material, those are the manufacturing categories that really have, in my view, dropped the ball on not only testing but labeling their products so the consumer knows exactly what it is they're buying. You can't help but go to a big box retailer, home improvement store, and find hundreds and hundreds of different flooring options to which the consumer is inundated by color, pattern, price, all the various components that they ultimately rely upon to make a buying decision. But what's absent, Ralph, is information relevant to safety. In fact, most manufacturers don't even talk about it.
What kind of information could be conveyed to a shopper who has to make the decision? This is pretty technical stuff. Are you talking about certain rating systems or what?
Well, actually, in 2009, the American National Standards Institute, an organization most likely known or commonly known as ANSI, authored a series of standards specifically addressing this subject. And the standards involve testing of what's called coefficient of friction or slip resistance of flooring materials, and then labeling them per a unified, uniform national labeling system. Looks kind of like a gas gauge on your car where it points to empty or full. And manufacturers were encouraged to adopt the method and begin labeling their products, which sadly, here we are in 2017, and not a single manufacturer has adopted nor uses or tests or labels any of their products, thus exposing the consumer to an unexpected and unanticipated slip and fall event, sadly, which oftentimes results in serious injury or even death.
Well, you've taken your fight against the flooring lobby. Can you imagine there's a flooring lobby that resists improving the traction of their flooring materials? You've taken this fight all the way to the Consumer Product Safety Commission in Washington, D.C., which sets various standards for household appliances and other products. And you and others filed a formal petition a couple of years ago when the Obama administration was in office to get the commissioners of the Consumer Product Safety Commission to issue standards that would upgrade flooring materials so there'd be less slippery surfaces and less injuries and other calamities. What happened?
Well, you're absolutely right, Ralph. In 2015, the National Floor Safety Institute petitioned the U.S. Consumer Product Safety Commission to mandate that manufacturers of floor coverings test and label their products as to inform the consumer. We had about equal number of supporters as we did opponents. The majority, if not all, those in opposition were manufacturers and suppliers to the floor covering industry who adamantly opposed the development of the standard. It came down to a close vote. It was a 3-2 vote by the commission to deny our petition, but we are going to be repetitioning the CPSC sometime this fall. So it's going to be coming back. We have modified our petition. We've built our coalition. We've collected more data. Sadly, the problem continues to get worse. And on behalf of the American public, we feel it important that they know exactly what it is they're buying. Now, Ralph, if somebody wants to buy a slippery floor, they're welcome to do so. They just need to know it's slippery. Where today the consumer assumes that all floors are the same, that they're all safe, otherwise they wouldn't be sold, when in fact that's quite the opposite. Our research shows that about 20 to 25% of hard surface flooring materials would rank in the low traction range. That presents the highest risk of a slip and fall, where people both in the workplace as well as home are walking on these surfaces, both under wet and dry conditions, with all types of shoes. So what we want to do is really inform the public. We're not really asking for regulation as much as we are information to bring the public up to speed on what exactly it is that they're buying, because it's all too common that the first time somebody encompasses a slippery floor, it's too late. They've already fallen. They've injured themselves. Another interesting statistic is the most likely cause for a nursing home admission is due to an accidental fall. Everyone over the age of 70, Ralph, lives in fear of falling.
Russell Kinzer, what do you advise people? Because flooring today is installed. It's not going to be ripped up, with few exceptions, with better traction flooring. What do you recommend that people in their ordinary rhythm of life do regarding the shoes they wear and the way they walk around?
Well, again, it all starts with standards. In the area of walkway safety, floor safety, shoe safety, there have never been any standards by which industry has been held accountable to. There never were test methods to measure coefficient of friction or slip resistance of floors before the ANSI committee, the NFSI B101 committee, which authors these ANSI standards, was established. And that was just in 2006. The same is going on right now for the footwear industry. There will be a test method issued next year for testing the slip resistance of shoe soles to measure just how slippery they are. If you're to go to the market today and buy shoes, whether they're dress shoes or work shoes, you have no idea just how slippery those shoes are until you fall. So what we're trying to do is create a level playing field. We want to create standards and promote information and education to the consumer so they make better, more informed buying decisions.
Are you going to take on the 3 to 4 inch spike heel that drives podiatrists up the wall in terms of the effect of the whole vertebrae and so many falls and broken ankles? What's your view on that touchy subject, Russell Kenzier?
Well, you bring up yet another good point, Ralph. I really underestimated that by pioneering safety standards that I would draw so many opponents, out of nowhere. We've made quite a few friends, but even more enemies, because once you start standardizing things like heel height and sole slip resistance and floor slip resistance, not to mention another standard that will soon be coming out regarding floor cleaners. It might surprise you to know that the way you clean your floor, the chemicals that you use oftentimes will contribute to making your floor slippery. In fact, some of the research we've done 10, 12 years ago show that the majority of household floor cleaners actually make your floor more slippery every time you mop it than had you not mopped it at all. And so your point about shoe heel height and all the components that deal with pedestrian safety ultimately have to be addressed by developing nationally recognized consensus standards and holding the manufacturers of those products accountable to producing better, safer products, and simply inform the buyer, the public, as to any potential hazard that might be related to the product. And if somebody wants to buy spiked heeled shoes for whatever reason, they're welcome to do so, but understand that there is an inherent risk, and that risk oftentimes can really result in a serious injury or fatality. In fact, just the other day, Ralph, the Secretary of State Hillary Clinton, former Secretary of State Hillary Clinton, fell downstairs and broke her ankle. In fact, this was the second time that we know of that Mrs. Clinton actually had injured herself as a result of a fall. She falls right into the demographics of most likely victim. Her age, a white female over the age of 65, she fits it perfectly. And by the grace of God, she didn't get killed, but she could have. Falling down the stairs, as you mentioned a moment ago, especially at home, is very, very common. It's one of the leading causes of home fatalities. And so we see celebrities all the time who are injured, but we don't necessarily focus on what caused the injury, and many times it's a fall.
We'll talk about causation and negligence. Let's go to where you really mean business and where you get some of your income as an expert witness in litigation. And let me tell you, you go around office buildings now and you see placards on the floor, wet floor, be careful. They never used to do that many years ago, most of them. But now, because they know they can be sued and they're getting pressure from insurance companies to be more careful when they're mopping floors or when they're mopping floors or waxing floors, this comes from the fear of litigation, which makes them more careful. Can you characterize the state of litigation where there really is external negligent causes that lead people to fall and get injured?
Certainly, falls are specifically what we call same-level slips, trips, and falls. We're going to put aside falls from elevations, meaning people that fall downstairs or fall off of their roof in the wintertime shoveling snow, which, believe it or not, people do that. Just looking at same-level slips, trips, and falls, it is the single biggest cause of injury and death, and oftentimes that leads to litigation. One of the big drivers, which might surprise your audience, is our healthcare problems. Many people that get injured as a result of a fall and perhaps break a bone, a broken hip, or just have some form of injury, the medical coverage, the medical cost it takes to repair these people is very, very expensive. It's roughly $50,000 for a hip replacement, not counting rehab and any additional medications. It's not uncommon to see medical injuries related to an accidental slip and fall to top $100,000, and many people simply don't have the coverage or the resources to pay the bill, so they're forced into litigation. What's also interesting to note is most of these individuals that are hurt, specifically in companies and businesses, really don't want anything but their medical bills paid. They're not really looking to to cash in, which is oftentimes a mischaracterization by the media that these are just gold diggers. It's very, very rare that people really want to sue anybody. Most Americans are not wanting to file a lawsuit, but they feel compelled to because they have big medical bills. And they look to the property owner who created the hazard to simply cover their medical costs, which it's not uncommon that they get refused. In fact, that is typical. The typical slip and fall complaint or injury claim usually goes with a denial. The insurance company behind the property owner will most likely deny the claim, forcing the individual to litigate their case. And I've been involved in, as I mentioned, almost 800 matters involving a slip, trip, and fall, representing both plaintiffs and defendants. I'm on both sides of the docket. I see it both ways. But the problem is getting bigger. It's getting more expensive. It's on the uptick, and our healthcare system, is a contributing factor to driving the cost of these injuries, the cost of medical coverage for these injuries up.
I must say, it's very hard to win a slip and fall case in court. The juries start out with severe skepticism about, well, it's the person's fault. Because, their experience is that people often do not take care, and when they're going downstairs or they're rushing around, and they slip and fall. But you're talking about major institutions that are not taking care with the flooring for the public traffic that they are encouraging to proceed with their own business. We're running out of time. Can you tell our listeners how to get this book without mentioning Amazon and what your website is?
Certainly. If they have an interest in learning more about the book, they can go online to our website, which is floored.com, or they can also reach it on flooredthebook.com. You can see an overview of the book, the various chapters of the book, and it really appeals to a very broad range of readers. This is a book that doesn't necessarily apply to lawyers or insurance people, although they are also purchasing it, but really just the general public, to really dispel the myth about slips, trips, and falls. And these are not con artists. These are just regular folks like your viewers who are not wanting to file a lawsuit. They didn't want to be injured, but they were. And the negligence that's oftentimes connected to these injuries are serious. You bring up an excellent point on close, and that is that they are difficult cases to win. They're not easy. But for many people, that's their last resort. That's all they have is the civil justice system to protect themselves and to defend their rights. And sadly, as the baby boomers age, Ralph, this problem is going to just continue to rise until efforts are made primarily really by the federal government to start mandating standards.
Those are the two sources. Yeah, those are the two sources of progress. One, there needs to be a standard, enforceable standard that encourages the flooring industry to improve their traction, et cetera. And the insurance companies, who are supposed to be interested in loss prevention so they get fewer claims, they got to put more pressure on the flooring lobby and office buildings and factories, et cetera, to be more careful. Well, we're out of time. Thank you very much. We've been talking with Russell J. Kendzior, who is the author of the very readable book, Floored, Real-Life Stories from a Slip and Fall Expert Witness. You can't read this book without being more careful in the way you walk as you step forward on a daily basis. Thank you very much, Russell Kendzior.
Thank you, Ralph.
So, Ralph, we got a couple of comments from listeners based on last week's show. Is some pushback, actually, from a couple of listeners in Northern California who listened to last week's show when we were talking to Roseanne DeMauro, who had been evacuated because of the huge fires in Napa Valley. And one listener, Lynn Cobb, found our conversation about that, quote, irritating, and stated that there are 11,000 firefighters from all over the country here helping, even as far away as Australia. They're dropping water, retardant, and bulldozer lines all over the area. It is true that this is the worst fire in California history, but there are thousands of firefighters and equipment in many areas saved. She says, I love your show, voted for you twice, but please give credit where credit is due. Exaggerations will only drive potential supporters away. And another listener, Jeff Brody, responded similarly. He said, your guest stated Santa Rosa is gone. With the breathless intensity and thoughtlessness of a network news anchor, she stated that they were just letting communities burn. These statements are foolish and inaccurate, to say the least. They undermine her credibility and yours. There are real questions here about how we live, climate change, and the a-hole in the White House, but they don't warrant a local coming on your show making statements that anyone on the ground knows are ridiculous. How would you like to respond to that?
Well, it makes me think of the old saying, it's not what you say, it's what they hear. Roseanne DeMora, who heads the California Nurses Association, lives in Santa Rosa, and she was talking about a ridge a mile and a half away from her home. She was forced to evacuate by police order. She was talking about a ridge a mile and a half away from her home that was on fire, and it was not being confronted, from which she concluded that there weren't enough firefighters. She praised the firefighters, said how exhausted their valiant work has been. And I joined by saying I don't think there are enough resources. There need to be more airplanes and helicopters dropping water on these areas in a strategic way, and there need to be more firefighters. So there wasn't any attempt to disparage the courageous work and brave work of the firefighters. But, she was fearful that she was going to have her home burned down, and so she made that statement about the ridge. When she said Santa Rosa is gone, that was more of a fearful prediction of where the fires were heading. They'd already burned down dozens and dozens of homes in Santa Rosa, as one of the questionnaires recognized. And fortunately, her prediction thus far was not borne out, and Santa Rosa will be protected. But I think that when somebody is fearful of losing their homes, and nurses that she's responsible for volunteering in Puerto Rico having their homes already burned down, you give people like that a little leeway when they express fearful observations about what they think is about to happen.
I want to thank again our guest today, Professor Margaret Jane Radin, author of Boilerplate, and traction expert Russell Kendzior. For those of you listening on the radio, that's our show. For you podcast listeners, stay tuned for some bonus material we call The Wrap Up.
For Ralph's weekly blog, go to nader.org. For more from Russell Mokhiber, go to corporatecrimereporter.com. Join us next week on the Ralph Nader Radio Hour when we talk to former FCC Director Nicholas Johnson about media reform and investigative journalist Carrie Gillum about her expose on the corruption of politics and science and use of the pesticide Roundup. We'll talk to you then, Ralph.
Thank you very much, David, Steve, Jimmy, and for our listeners, spread the word. Try to get more radio stations to carry the program and get more of your friends to listen to it. We try to suggest ways that people can protect themselves, become vigorous citizens in the struggle for justice, and the more listeners, the more likely that improvements will occur.
Welcome to the wrap-up, where I asked Ralph about when he writes UD on a contract and whether that makes a difference. Ralph,
yes.
When you write UD at the bottom of a contract, is that a legal binding thing, or is that something that's recognized as in court?
No, it's never obviously been tested, but it's an indication that I was under duress and did not volunteer my consent.
So if that were to,
it helps you. If that was in litigation, yeah, it would help you. Because they say, you consented. Yeah, I consented. I didn't have a choice. You didn't give me a choice. I had to have the doctor. But you can see I put under duress.
And then we spoke a little bit more to Russell Kendzior about floors. Thank you, Russell. I was unaware that there was a lobby, like big floor.
Oh, it's like the auto lobby.
Yeah.
It's unbelievable. I mean, they're ferocious, right, Russell?
Oh, it's beyond ferocious. But the problem is, guys, and this is an issue that I think AAJ is going to pick up, and that is that we're looking at what could be the largest class action lawsuit in American history. Imagine the tobacco industry suit times 10. Every person that slipped and fell as a result of an unsafe floor that the manufacturer of that product intentionally and deliberately chose to hide from the consumer, they're now liable. Imagine how many slippery tiles, flooring materials are out in the world today. And Ralph, I don't mean tiles or floors that became slippery by improper maintenance, but stuff right out of the box. Don't forget, gentlemen, most of this stuff is made in China, where there's no standards. It comes in large boatloads, they rebox it, and next day it's on the floor, showroom floor at Home Depot.